During settlement negotiations, when the defense comes to me and says, listen, we'd like to start negotiating, but we need some additional time to conference the case with our principals. What does that mean, they need additional time? Is that a good thing or is that a bad thing? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is, it might be a good thing, more likely than a bad thing. Now you turn around and say, wait a second, does that mean that they need additional time because they're now going to do a deep investigation into me? That they might start following me with a private investigator? They're now going to do a background search on me to determine whether or not I'm worthy to obtain or receive a settlement offer? And my response to that is, no, that's not what's going to happen. You don't know it, but they've already done that. They've already done a background search on you. They've already done a criminal investigation search on you to see if you have any criminal activity in your background. They have done a search as best they can to evaluate your social media way before you ever reach the settlement stage. Now, why is that? It's because they want to know whether there's something in your background, something on social media, something in your criminal past that might show up that they can use against you during the course of your lawsuit. And prior to you being questioned in a pretrial question and answer session known as a deposition, lawyers also call it an examination before trial, they will ask you questions about whether you've ever been convicted of a crime before. They will ask you questions about your social media posts, whether you have ever put any photographs or comments about your physical activity on social media, or talked about the doctors in this case. And the reason they do that is because they want to lock you into your testimony. They will already have done their search by the time you are now questioned in your lawsuit. So when you now reach the point down the road, maybe 2 years down the road, 2.5 years, maybe 3 years, because these types of civil lawsuits in New York can take anywhere from 2 to 3 years from start to finish. By the time you now reach the point where the defense is interested in negotiating, they have already done their background search. They have already investigated you. If they were going to go ahead and get surveillance video, in all likelihood, they will already have done it in most cases. So now you ask, why do they need additional time? Often they need additional time because they now have to present your case to the various people at the insurance carrier, and there are different layers of people that they need to present it to. Many times they only meet a certain number of times per month, and now they have to get on the schedule in order to discuss your case. When I said earlier that it might be beneficial for the defense to have additional time in which to go ahead and evaluate your case, I said that because now they will go ahead and present your case to their principals and then come to a decision or come to a conclusion about whether or not they should start negotiating, and then they will determine whether to give their attorney authority in which to start negotiating. So why do I share this quick information with you? I share it with you to open your eyes and help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. If you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.